Good afternoon, everyone, and greetings from Slovenia. It's a pleasure for me to attend this conference, unique conference, I should say. I'm glad to have the opportunity to address colleagues from the research team as well as other participants. I wrapped up my research findings in a presentation which I wish to share with you. So let us see if I can put it on the screen. It might be a challenge because yesterday I wasn't successful with doing it. Let's see if I can make it. No, I cannot make it again. So I will do it without presentation. I hope you don't mind, and I will have it here to help me. No, I cannot. Sorry. Okay. I will be talking about interpretation of fundamental rights in the practice of the Slovenian Constitutional Court. I will begin with some basic information on the Slovenian Constitution and Constitutional Court. The new Constitution of the Republic of Slovenia was adopted in December 1991. It was 6 months after Slovenia gained its independence from the communist Yugoslavia. And in the new constitution, there is an extensive catalog of human rights and fundamental freedoms. And also there are basic provisions on the status and powers of state and independent bodies, including the Constitutional Court. Actually, the Constitutional Court was introduced in Slovenia already in 1963 by the then socialist constitution. However, the new constitution with the new constitution, the Constitutional Court acquired new important powers as well as a stronger position within the judicial branch of power. So the new constitution defines Constitutional Court as the highest body of judicial power for the protection of constitutionality, legality, and human rights. Status and powers of the Constitutional Court are determined in the Constitution in an independent chapter. However, they are more precisely regulated in Constitutional Court Act, and also the Constitutional Court has its own rules of procedure. 9 judges of the Constitutional Court are elected on the proposal of the President of Republic by a majority vote of the National Assembly. Lately, the Slovenian President Borut Pahor has had some problems with nominating the candidates, but this is an issue for another presentation. The Constitutional Court judges served 9 years term, and any Slovenian citizen who is a legal expert and has reached at least 40 years of age may be elected. So in Slovenia there is no condition such as passing bar exam or something similar. The office of a constitutional judge is incompatible with any public or private office or work. And also, constitutional judges. No. I think we have some disturbance. Also, constitutional judges possess immunity from criminal liability, which is comparable to the one of members of parliament, meaning that it is material and procedural on the one hand, and also professional and non-professional on the other hand. The Constitutional Court possesses extensive jurisdiction intended to ensure effective protection of constitutionality, legality, and also to prevent violations of human rights. And among various powers, 2 are most important. One is the review of the constitutionality of laws and other general acts, and also power to decide on constitutional complaints regarding violations of fundamental rights. All other powers are comparable to the powers of the Constitutional Court in the region, I would say, and also in general in Europe. And I will not express them explicitly in this presentation due to the lack of time. Regarding my research of interpretation of fundamental rights in the practice of the Constitutional Court, I would say that my research was a little bit more ambitious than the title of the research would suggest. Namely, it was aimed at providing a comprehensive record of the common features of the Slovenian Constitutional Court's reasoning and adjudication in fundamental rights cases. And for this purpose, 30 important cases of the last 10 years were analyzed, and they were analyzed according to the common methodology which was presented by our team leader earlier this morning. And most of these cases have had precedent effects on the Slovenian legal order, and some of them also have led to amendments in different areas of legislation. First of all, I would like to address, not in detail, but at least in general terms, a normative framework of considering and adjudicating cases. Constitutional Court considers cases in accordance with the order of their receipt. However, it may decide to consider certain types of cases as priority ones, and also some cases shall be considered as priority ones ex lege. Constitutional Court considers a case and decides upon it on the basis of either a submitted draft decision or a written report prepared by the judge rapporteur. Namely, in certain occasions, the judge rapporteur can estimate that the case is more complex or more demanding, and then he would or she would prepare a written report for the judges. And in most cases, the draft or a report is prepared by the judge rapporteur alone or together with other judges and advisors. However, there are also cases, and this is my insider information because one of my colleagues served as an advisor. Sometimes an individual advisor would prepare or could prepare a draft decision or more often a report for the judge rapporteur as well. But in any case, then the judge rapporteur would either sign the material and send it to the Secretary General for admission for the session, or he would give the advisor additional instructions how to amend or supplement the material before the material is sent to the Secretary General for admission for the session. And in any case, Judge Rapporteur should sign the material before sending it to Secretary General. Sometimes it happens that judges submit their motions in writing in this phase of procedure, and if they cannot be accepted by the Judge Rapporteur, then he or she would propose that a new Judge Rapporteur be appointed to prepare a new draft. However, there are also cases, or there are occasions where preliminary votes would be taken in order to verify the support that the draft prepared by the Judge Rapporteur enjoys, and then a new round of discussion would take place, and draft could be amended, and so on and so on. So when the material is ready, Constitutional Court considers a case either at a closed session or at a public hearing. There are provisions in the Constitutional Court Act about when the case is considered in a public hearing, but it's not so important, so I just go further. And after the discussion is concluded, the President of the Constitutional Court submits the proposed decision to a vote, and the final vote may be carried out only on the draft decision, which includes the operative provisions and its full reasoning. But there is also an exception in cases when the Constitutional Court pronounces its decision orally immediately after the conclusion of a public hearing. Then the operative provisions and the reasoning would be prepared post festum. And of course, Constitutional Court's final decisions shall contain some obligatory components, including operative provisions, statement of reasons, or reasoning, and also a statement of the composition of the court, statement on the results of the vote, and names of the judges who voted against the decision, names of the judges who submitted separate opinions, and also names of the judges who were disqualified from deciding. And the reasoning as an obligatory component of a final decision should contain summary of the allegations or arguments of the participants in the proceedings and the reasons for the decision of the Constitutional Court. Regarding characteristics of decision-making and style of reasoning, I would like to emphasize that this both depends very much on the type of a case. Whether the case is concerns review of the constitutionality of laws and other general acts on the one hand, or constitutional complaint case. In the further occasion, when the case refers or concerns the review of the constitutionality of laws, a norm control case can be initiated by a written request by applicants determined by the Constitutional Court Act. Mostly these are state bodies like 1/3 of the parliament, ombudsman, and so on. Or it could also be initiated by a petition which may be lodged by anyone who demonstrates legal interest. And legal interest would be demonstrated if a general act which is challenged at the Constitutional Court directly interferes with the petitioner's rights, legal interests, and legal position. Interestingly, in its case law, the Constitutional Court determined more precisely what this text defining the legal interest actually means. And according to the Constitutional Court, the legal interest would be demonstrated if the petitioner would be involved in the concrete legal dispute in which he or she would exhaust all regular and extraordinary legal remedies, and also a petition should be filed together with a constitutional complaint. And there is one additional condition, which is that the petition must be such as to raise particularly important precedential constitutional questions of a systemic nature. So all in all, I would conclude here that it's the Constitutional Court is not very easily accessible for the petitioners in Slovenia, and this was also visible recently. Has been visible recently with regards to COVID-19 cases. In the majority of normal control cases, petitioner would also propose the Constitutional Court to suspend the implementation until the final decision, and the Constitutional Court would do so, would suspend the Challenge Act, General Act, if the implementation could result in harmful consequences that are difficult to remedy. Regarding this temporary injunction, the Constitutional Court developed in its case law special interpretative formula, and when applying this formula, Constitutional Court wedges between the harmful consequences that would be caused in case of the further effect of the challenge provisions on the one hand, and their temporary suspension on the other hand. This was again very well visible in the COVID-19 cases, where the Constitutional Court was deciding upon whether to issue an temporary injunction or not. Well, the cases, the Constitutional Court carries out the review of the constitutionality by applying the test of legitimacy, test of proportionality, and also by deploying several methods of interpretation of fundamental rights and other constitutional provisions, of course. And since due to the lack of time, I will not go deeper into the issue, deeper into this test in my monograph chapter. This is, of course, analyzed a little bit more precisely and in detail. Prior to what was said was about the review of constitutionality of laws cases, and regarding constitutional complaint cases, prior to taking a decision on the merits, a panel of 3 judges at a closed session carries out preparatory procedure where it decides whether to initiate proceedings on the basis of a constitutional complaint or not, and the panel decides according to the criteria that are set up by the Constitutional Court Act. When deciding on the merits of a case, the Constitutional Court either dismisses a constitutional complaint as an unfounded, or grants it and in whole or in part annuls or abrogates the individual acts. And if the latter is the case, then the Constitutional Court would remand the case to the authority competent to decide thereof. However, but in very rare occasions, Constitutional Court could decide on the issue also by itself. Reasoning of the final decisions, or better to say style of reasoning in the statement of reasons in the final decisions of the Constitutional Court differ in the initial part and in the main part, I would say. In the initial part, where the court summarizes the proceedings before the courts of general jurisdiction, where the Constitutional Court lists the decisions that are challenged by the constitutional complaint, where the Constitutional Court presents the complainant's allegations and arguments in a more detail. In this part, style of reasoning is obviously descriptive and illustrative in its nature. However, in the main part, where the Constitutional Court adjudicated on the merits of the case, and where the Constitutional Court provides a detailed argumentation of its decision, the style of reasoning becomes predominantly prescriptive and normative in its nature, I would say. And also typical of style of reasoning in this type of decisions is, of course, deployment or employment of several tests, such as test of proportionality, also in the constitutional complaint cases, other tests, and also, of course, in this kind of cases, also different methods of interpretation are also applied. And regarding methods of interpretation, within my research, I try to answer the question which methods and techniques of interpretation are used by the Constitutional Court, and also with what frequency they are used. My study revealed that Constitutional Court uses and combines a wide range of different methods and techniques of legal interpretation, while some methods and their subtypes typically appear as decisive ones, others most commonly appear as strengthening ones, supporting the Constitutional Court decisions. And here should be stressed, I believe that in these occasions, these strengthening methods are not necessarily used as a tool for direct interpretation of Constitution. I will refer to this later on a little bit more. So I'm really sorry that I cannot show you my presentation, my notes actually on my research, because here I have a table which is comprised of my findings regarding statistical and quantitative analysis of the selected case law of the Constitutional Court. But this, in any case, this table will be included in my chapter in the monograph, which will be published in the aftermath of this conference. So anyone interested could take a look at it. Regarding the methods of interpretation, my study revealed that most frequently used methods of interpretation are domestic systemic arguments. They are contained in all decisions in my sample of case law, and they have been deployed in 50% of all identified instances of deployment of main types of methods. Of course, some types and subtypes of domestic systemic arguments are deployed more frequently than the others. Most frequently deployed were references to specific previous decisions of the Constitutional Court as precedents. They were identified in all 30 cases, and they were deployed in 28% of all identified instances of deployment of methods of interpretation, which is quite a high number, I would say. And since you cannot see my presentation now, it's maybe not sensible that I go into details regarding examples of applying this or deploying this method. Maybe just to mention, in one individual case, the Constitutional Court referred to more than 30 previous decisions, and this case was about a constitutional complaint of the Bar Association of Slovenia against Ljubljana District Court orders, which issued house search of the offices of 3 attorneys. And the Constitutional Court made reference to a specific previous decision while defining the meaning of privacy as, of course, a constitutional right. And there are several other similar examples given in my chapter, which will be published in the aftermath of the conference. Then the second most frequently used method of interpretation are external systemic and comparative law arguments. Also, these, in one or another form, are contained in all the decisions in my sample, and they have been deployed in 24% of all identified instances of deployment of main type methods. And again, not all types of this method are used with the same frequency, of course. And similarly, the most frequently used are references to the international courts. And to be more precise, among these, 81% of references in these 30 decisions were made to the decisions of the European Court of Human Rights. The rest were made to the European Court of Justice, and within these 30 cases, no references were made to other international courts, which is interesting, maybe surprising a little bit, although I'm quite convinced that normally, maybe in other cases, Constitutional Court would use, would make references to other international courts for sure too. In my chapter, I took an example, a case in which Constitutional Court has taken a precedent position on the issue of submission by a national court of a case to the European Court of Justice for a preliminary ruling, and in this case alone, there are 26 references to decisions of both European Court of Human Rights and the European Court of Justice. But most of the references in this case were made to the specific individual cases of the European Court of Justice. And when determining in length the legal nature of the ECJ in terms of the constitutional definition of an independent and impartial court, the Constitutional Court referred to several individual decisions of the European Court of Justice in a footnote. The third most frequently used method of interpretation is grammatical textual interpretation. Also, this method is contained in all decisions from my sample, and it has been deployed in 11% of all identified instances of deployment of main type methods. The most frequently used among subtypes of this method was legal professional dogmatic interpretation, and its subtype simple conceptual dogmatic interpretation. And this method is used when Constitutional Court uses a specific legal meaning of words that is uniformly accepted and recognized by lawyers. And there was use as an example in my chapter a case where the Constitutional Court used the simple conceptual dogmatic interpretation by referring to a simple legal meaning of words, to a special legal meaning of words, of a legal entity. So this here obviously was, this method was applied. And also, but however, this method was not applied in sense of a direct interpretation of the Constitution or of the provisions of the Constitution on human rights. However, in the same decision, there is also an example of deploying of this method while directly interpreting the Constitution, where the Constitutional Court determines the possibility to establish the legal entity as one of the aspects of the freedom of association. The fourth most frequently used method of interpretation were arguments based on scholarly works. They were contained in 26 decisions out of 30 which were taken, which were selected in my sample, and this method of interpretation was deployed in 10% of all identified instances of deployment of main types of methods. Interestingly, largest share of references were made to scientific monographs. It was 52%. Then 26% of references were made to commentaries, and 22% of references were made to scientific articles. Regarding references made to commentaries, interestingly, more references were made to commentaries of statutory laws than to the commentaries of Constitution. This was, for me personally, quite a surprise. And again, in my chapter, there will be you will find some illustrative examples where the Constitutional Court referred, in most cases in footnotes, to scientific monographs, to scientific articles, and to commentaries. For instance, in one case, the Constitutional Court did so while explaining the essence of the privilege against self-incrimination. In other case, while addressing the international legal principle of non-refoulement as a component of the constitutional rights of asylum. All other methods of interpretation were used much less frequently in the practice of the Slovenian Constitutional Court. Theological interpretation, teleological interpretation, logical arguments, historical interpretation, interpretation in light of general legal principles, and non-legal arguments. All these methods of interpretation were deployed in less than 2% of all identified instances of deployment of methods of interpretation, which means that really rarely, but although I'm sure that maybe the result would be different if I would pick in other basin of Constitutional Court decisions. So the last question which was asked, according to the common methodology of our research group, was which methods of interpretation that are used by the Constitutional Court are typically appear as decisive ones. And here I should emphasize that it's sometimes difficult to distinguish between methods and arguments that have decisively contributed to a particular decision, and those those for whom it cannot be said. And also, in some cases, there are several decisive methods and arguments in the Constitutional Court decisions. However, according to my findings, most often used as a decisive method of interpretation was simple conceptual dogmatic interpretation, where Constitutional Court uses a specific legal meaning of words that is uniformly accepted and recognized by lawyers. And also frequently uses decisive argument were references to the place of the provision to be interpreted in the Constitution, which is the contextual interpretation in a broad sense. I found some cases where the Constitutional Court deployed both methods of interpretation that are most frequently used as decisive ones. So both were applied or deployed in the same in one or in the same decisions. For instance, one of such decisions was a decision in a case where the Constitutional Court reviewed the constitutionality of the Prevention of Restriction of Competence Act. What can be said at the end of the day about the reasoning and adjudicating in the fundamental rights cases by the Slovenian Constitutional Court? Well, I would say that characteristics of decision making depend largely on the type of the case. Regarding style of reasoning, I would say that it depends. It could be descriptive and illustrative on the one hand, and prescriptive and normative in its nature on the other hand. But it depends on in which segment of the statement of reasons in the final decision it is situated. Also, I would like to point out that a Constitutional Court style of reasoning, typical of Constitutional Court style of reasoning, is also the application of different tests, standards, and argumentative formulas. And of course, that Constitutional Court uses and sometimes combines wide range of different methods of legal interpretation. And while some methods and arguments are and their subtypes typically appear as decisive ones, others are most often deployed as strengthening ones or strengthening methods.
Thank you.
Excuse me. Just to conclude. Final thought. Obviously, interpretative tools which are most frequently deployed in the practice of the Slovenian Constitutional Court are not the most important and decisive ones, which means that what is most common and popular is, as a general rule, not essential and decisive, even when it comes to the constitutional reasoning. That would be from my side, and thank you very much for the attention.